The expression digital assets is linked to anything that is digital in nature, even if it is not proprietary. Under English law, the pure information that makes up a digital photograph, sound, or video is not in itself property, but it can be associated with rights, such as copyright, that are property and can be transmitted on death. Another property interest commonly associated with digital information is the benefit of a contract. One example of such a contract, which involves the manipulation of digital information, is the contract between Spotify and a user of its streaming service. Data that originate from services belonging to or under the control of Spotify are sent to the user's computing device. The receipt and use of those data are authorized by the user clicking on or tapping a notional button that reads, "I agree." Included in the terms and conditions applicable to that contract is a provision that the service provider grants the user limited permission to make use of the streaming service until termination. This permission can, by definition, be enjoyed only while the user is alive. The Facebook terms of service have a similar character. They grant the user the opportunity to connect with other people, to express themselves, and to communicate with others by uploading text, images, or videos. Conversely, they permit the user to receive communications from others. Again, the language is expressed in terms of enjoyment and use while alive. The user must use his real name and must not share his password. So, when he has died, no one should have access to that account. The only exception to this is if the account has been memorialized and the user has duly designated a legacy contact, in which case limited disclosure from the account can be sought. But the user does grant rights to Facebook that last longer than his lifetime. Although his intellectual property rights in the content that he uploads to Facebook are preserved, he is required by his agreement to grant substantial rights over that content. Of course, there is provision for the user to delete content, but that will not be fully effective while any copies of it are being used or displayed by other users on their Facebook pages. In addition, the user grants permission for Facebook to use his name, his profile, picture, and information in connection with advertisers. So if the user has liked a product advertised on Facebook, his picture and information about him can be shown to his friends, apparently without limitation in time. But this is relatively mild when compared to the rights given to TikTok. If the user uploads content to that platform, it is allowed to manipulate and reproduce that content and publicly perform it without paying anything to the user. This permission is perpetual. Some cloud services do, of course, give rights to the user that can extend beyond death. But these generally involve payment of a fee for the services being provided and the platform holding some asset that is proprietary. Examples are gambling sites and payment services. For pure enjoyment and entertainment services, personal privacy is not generally at the top of the feature list. and that low bar is not raised after death. If anything, it is lowered.